also, you know, independent investigation that you can do based on the style of case that you have. For example, in a self-defense case, it's often that the victim will have prior acts of violence against third parties. And in Georgia, that evidence comes in under a case called Chandler versus the state. You know, if you have a self-defense case and the defendant testified that he acted in self-defense, that the victim was the aggressor, and there's no Chandler evidence in the case, and your trial lawyer doesn't have a file where he's pulled the victim's record under from GCIC, which is Georgia Crime Information Center, then that would suggest to you that, well, that's something you need to look at. You need to make a request, get the victim's record. Who knows, he may have a bunch of incidents where he was the aggressor. He may have a long history of being an aggressor. That evidence would have been admissible. And if that's something that the case may have turned on, then that's going to be very important. In terms of, again, talking with trial counsel, one other thing that you want to make sure happened was that, you know, if there were plea discussions, trial counsel is required to communicate those plea discussions to his client. Okay, and this is another thing where you can be talking to your client, and you know, if you didn't talk to your client, you may or may not know how this resolved itself. But one thing I always ask my clients, just like an automatic thing when I talk to them, is, was there a plea offer in the case? What was it? What was your response? Yes?
What on a plea or other evidence of ineffective assistance of counsel, your source is your client. He's taken the fifth. I mean, you have to put him on the stand to prove that.
I mean, let me answer it this way. One situation that might present itself is, let's use the plea as an example. You talk to your client, and he says, I never got a plea offer. I never heard a plea offer. You know, I would have liked a plea offer. Didn't really want to go to trial. The case, he didn't really have any defense at all. But I've had this happen. You know, you look at the case, and you're like, why didn't this case plead out? I mean, it's just, it's like, this was a loser from the get-go. And so your client says, I didn't get a plea offer. And then you go and talk to trial counsel. Were there any plea offers made? Yeah, they offered 15 years to serve. Did you communicate that to your client? Yes. Now you have a competing, you know, factual circumstance that, I mean, you could make that claim, but if that's all you got, you're probably not going to get too far, because, you know, the judge is sitting because the trial fact in the motion for new trial here, he makes an adverse credibility determination that's adverse to you. You know, that is, just blows it out of the water. You can put that on if you want. You know, you might want to talk to the DA. Was there a plea offer made in this case? Yes. No. You know, in Fulton County, they normally write it down in their files. That would be sort of like a simple factual situation, but it can go in any direction. And again, if you're in a situation where it's the client's word versus the attorney's word, in my experience, most of the time the attorney's word is going to carry the day. You're going to lose that claim unless you can find some other evidence that's going to corroborate what your client is saying. Does that answer the question? Yes?
So to raise an ineffectiveness claim based on failure to investigate, when we take one of these cases, when our second or third year associates working on the case,
Right.
They basically have to reinvestigate the case.
Not necessarily.
Well, are there some cases where they have to reinvestigate the case and track down witnesses who were in?
Well, I mean, this is another thing. When you're talking to your client, I mean, one of the standard things that I talk to my clients about is, you know, were there any witnesses that you thought were important that didn't testify at trial? And they may say yes, and if so, then who were they? I need to know who they were. I need to talk to them. I need to talk to wasn't called. Why wasn't that witness called? Well, trial counsel says, you know, I talked to that witness. They couldn't tell me the same story, 3 minutes apart. They were a horrible witness. That's not going to make a good ineffective claim for failure to call that witness. Just about, unless, that witness has made a prior statement somewhere, maybe in a police report, and, that they're singing the same tune, and it's still going to be a tough call, Jim.
Oh, I just wanted to follow up on what you said. In a case like that, your example, which is fairly common, the two things illustrates the breadth of a performance that can be reasonable. The court's going to be highly deferential to that lawyer's judgment because they're not ever going to be able to put themselves in his shoes to make that. And if he says, yes, I talked to this person was a lousy witness, that's it. That's the end of the case. That's not a witness that needs to be investigated because it doesn't make any difference whether you run that witness down and you decide this witness is, reincarnation of John the Baptist or something. It's not going to go anywhere. It doesn't change the reasonableness of the lawyer's determination. Because again, we're all different, and you may, we may even evaluate people differently like that.
And I'll say this also. There's the legal standard that you're dealing with, and then there's the judge that you're dealing with at a motion for new trial. And there's an off-sided legal principle in Georgia that there is no cumulative error rule in Georgia. But when you're dealing with a motion for new trial hearing and you're in front of that trial judge, and you have a judge who's receptive, and you have a close case, and you can throw enough on the wall that it might start sticking, that's a case where, if that witness seems really forthright, depending on who trial counsel is, they may or may not get a lot of respect from that judge. In a certain situation, I could see where you might say, well, I'm going to present that. I know if I lose at the motion for a new trial hearing, I can't do a thing with it on appeal. But it might get some legs, or it might help just create this sort of perception of this just wasn't done right at trial. And it might help you on another issue that you have that's close, in the sort of overall fairness perception of the judge. You may say, well, yeah, I'm going to grant you a new trial on that. Now, there are judges that won't work with it at all. There's some down in Fulton County where it will.
Let me answer that question about reinvestigating the case in this way. I think the ineffective assistance claims run the spectrum. Mostly, you're talking about specific errors. The trial attorney made some specific error, very discrete error, and then you can show it or not. But if you can show it, then you have to move on to the prejudice prong, and that's it's almost all within the record. There's very little you need to do. A more complicated case, like the cell phone records, you might have to reinvestigate the case. You might have to look at the cell phone records. Your client tells you, my attorney didn't investigate this, didn't investigate that. You do check with the trial attorney and see what he did. I've had, you get cases where the client tells you, I have alibi witnesses, and the defense attorney just didn't call him, and I've had a situation where the defense attorney said, yeah, I just didn't, I didn't really go that way. The client really wasn't very persuasive about that. But your client's telling you about these witnesses. You generally are going to need to go and talk to the witnesses, see what they would have said, see what they would have testified, and maybe present them. And that gets to another level. It's not just reinvestigating, but it's retrying the case. You may end up at a hearing where you're actually almost full-blown retrying it. And let me tell you a case that is not a reported case because it was resolved at the motion for new trial stage that I think encapsulates. It's a case that I'm just going to remember forever. This little child suffered from sickle cell anemia, 2 or 3 year old child, I guess, being treated by a hematologist, and went to the hematologist on Monday, and the hematologist went by the book and gave the child an infusion or whatever they do, and sent the child on the way, sent the child and the parents on the way. A few days later, a week later, the mother, or the child's parent, drops the child off at someone else's house, a babysitter, a caregiver. And a couple hours later, the child is in bad distress. 911 is called. They show up. The child is lethargic or whatever. Bring the child to the hospital. Child dies. Nothing bad happens except that it is seen through the eyes of the criminal. So the police arrest the caregiver for killing the child, shaken baby syndrome. Police love this. Prosecutors love this. This is shaken baby syndrome. The child must have been misbehaving or crying, whatever, and the caregiver shook the child, and that caused brain whatever, and the kid dies. The woman's never been in trouble before. Suddenly she finds herself charged with murder. They go to trial. The treating physician testifies that this could not have been a complication of the death, the illness that led to the death, the sudden onset of symptoms, could not have been the result of sickle cell anemia. That she had treated the child correctly, that this infusion, the child would not have presented that way from sickle cell anemia. So all that's left is shaken baby. This woman must have killed the kid. The defense did not put up any expert to counter the treating physician who testified as an expert. Woman gets convicted of murder, gets sent to prison for life. And I will say that the trial attorney, for what it's worth, is a good trial attorney. New attorneys come on, and it goes up and back for procedural reasons to the Supreme Court. Comes back, and they have a hearing in front of the trial judge, and this is where we're talking about retrying the case. By this time, the new attorneys at the motion for new trial stage have gotten an expert, or several experts, and they look at the records. They look at the medical records of the treating physician. They look at the autopsy, all that kind of stuff, and these new experts that were never, the original trial attorney had never asked for funds to get experts, never had experts review the records. These experts testified essentially that the treating physician had committed malpractice in the way that she had treated the child, and put a very serious doubt in the judge's mind about whether it could well have been a complication of sickle cell anemia that killed, that the child died from. And if there's a real possibility that it was sickle cell, well, then clearly there's a reasonable doubt about the woman, the caregiver, committing murder. And then just to end the story, the trial judge granted the motion for new trial. The state, very surprisingly to me, retried the case. This time, and then the next set of lawyers come in. The treating physician testifies again, but this time she is confronted and raked over the coals. I mean, she undergoes a really thorough cross-examination. So yes, you may need to really do a thorough retrial of the case.